We will discuss about civil cases. In civil cases, first gather information about Civil Procedure Code, Transfer of Property Act, Specific Relief Act, then Trust Act, Registration Act, Stamp Act, etc., and also Contract Act. After going through all these acts, see what type of cases are being filed, which are of civil nature: money suit, title suit, cancellation of deed, then a specific relief act, eviction suit, redemption of mortgage, etc., and some matrimonial cases like restitution of conjugal right, judicial separation, divorce, etc. Now, a plaint has to be drafted. In the beginning, a lawyer should take help of senior, because plaint is the main thing. You have to establish every fact. If you are not having any document in your possession, write it in the plaint itself, that in whose possession the document is kept, and those documents which are with you, xerox along with plaint, has to be filed. Check valuation of your suit, in which court it can be filed, and then pay a valuation in the form of a stamp, non-judicial stamp, and after solicitor report, get the case admitted, issue notice to defendants. इसके बाद जब डिफेंडेंट लोग आ जाते हैं या सर्विस सफिशिएंट हो जाता है, नहीं भी आए लेकिन पेपर पब्लिकेशन हो गया, substituted summon, it is called order 5 rule 20. Then plaint has to be filed under order 7. Then defendant will file WS within 90 days of receiving summon. It is 30 days only, but in special cases date can be increased to 90, and after paying cost it may be even more, but it is advisable to file WS within 30 days, and then file all the original documents in the court. If needed, in a box write document for plaintiff, document for defendants, then give proposed issue. Court will frame issue. Issue means that what is the bone of contention. For example, in matrimonial case, husband denies that she is my legally married wife, and wife says, no, I am married. Then this will be one issue, whether the marriage between plaintiff and defendant was solemnized or not. This issue has to be decided in the case. After issue, plaintiff gives his evidence along with his witnesses and adduces evidence. Those documents who are original or public document that can be exhibited. Those who are xerox can be marked as exhibit X, marked as X, not exhibit is used. And then if in some document defendant raises question, objection, then plaintiff will have to prove that by bringing original. If the defendant doesn't object, then it is it may be considered by honorable court. After plaintiff's evidence, defense defendant gives evidence, argument and judgment, and accordingly decree is made. What was the cost of suit, who will pay the cost of suit, and what is the decree. Judgment and decree. Judgment is reason why plaintiff has won or defendant has won, and decree is what is the final result. So in civil cases there are something more. For example, orders are there of two nature. One is appealable, in another revision is being filed. If it is ex parte decree, then defendant can file in order 9 rule 13 in the same court, showing that he didn't receive the summon, or someone was sent at a wrong address. And if he is able to show valid reasons, then ex parte decree may be set aside. Then first appeal is a matter of right. In second appeal, only it can lie when there is substantial question of law or fact. So this is civil cases. In civil cases, one has to read sufficiently, must know all the important case laws, and initially seniors help must be taken in civil cases.